Over the years, I've had people come to me and say that they have worked out an agreement with their ex with regard to child custody or child support or whatever. And they did this a long time ago because they didn't want to go back to court. So they did what's called an out-of-court agreement. That can be okay. You can do it, but is probably not the best way to do it. So if you already have a custody order or divorce decree in place, and then later on the two of you say, hey, let's change something, let's agree out of court so we don't have to go back and spend money going to court and involving the judge and all of that. So long as the two of you can really trust each other and follow it, you can do it, but I would never, ever advise it as a lawyer. All right. So for instance, you have a child custody agreement that says joint physical custody, 50-50 timeshare of the child, and no child support because the two of you make about the same amount of money. And that's all in the divorce decree or child custody order. 2 or 3 years later, you have this little agreement that one of you is going to have the child a lot more than the other. And you just and in exchange, the person that has the child a lot more is going to get maybe $100 a month for that extra time or whatever. Then the person who's supposed to be paying the $100 stops paying, and even leaves the child more with the parent that agreed to take the child more. The parent that took the child more is now is upset. It's like, look, I'm spending all this extra time and I'm not even getting the $100 that I was agreed to. And so that person wants to go and enforce it in court. Chances are a judge not going to enforce that agreement because it wasn't done through the court. And by through the court, I don't mean spending a lot of money and doing a lot of unnecessary stuff. Through the court simply means that agreement could have been written as a stipulation with an order at the bottom of the stipulation. So the two of you sign the stipulation. All stipulation means is agreement. With the order at the bottom, you submit it to your judge in your family law case. The judge reviews it, says, okay, this is fine, signs it. You then enter it into your case, the same case that you had your prior order or decree in, and now that becomes the new order of the court. And it substitutes the old order from the decree or from the prior child custody or child support order. And that becomes now the enforceable stipulation and order. And you did not have to involve a lot of lawyers or spend a lot of time or have a lot of stress. You just simply made your agreement an enforceable order. And you can pay a little bit to a lawyer to review it, give you some pointers or so forth. And if you don't, you could still just do it on your own. If you have a lawyer review it, that the lawyer can make sure you've really considered all the angles of it prior to filing it. So I just want to let you know that agreeing out of court does not mean you shouldn't go and file it with the court as a stipulation/stipulation and order, especially if you really want someday the court to enforce it. If you don't have a stipulation and order and just a written agreement signed by the two of you, there's no guarantee a judge is going to agree with what you two agreed to on the side. The only order the judge really has to adhere to is the prior court order. So always when you're agreeing with an ex on anything, you should consult a lawyer and think about doing a stipulation and order as opposed to just your own little loosey-goosey side agreement. That is my pro tip, my expert advice for today.